Hello, good morning. My name is Jamal Khan. I'm the head of tax at Churchill Tax Advisors. Today is the 9th of September 2019 and we are doing a Monday morning tax brief. In this we cover cases from the tax tribunal or most recent cases from the tax tribunal. Today's first case is Skin Rich Limited, which was recently announced just over a week ago. This company appealed to the tax tribunal for HMRC or against HMRC's disallowance of a VAT claim. They claimed that they were exempt. They offered skin treatments which included Botox services and fungal nail treatment, and they claimed that they were exempt from VAT under whatever VAT Act 1994 Schedule 9, which general medical services where there is a medical problem, such services are exempt. However, the judges and HMRC did not agree that Botox services were as such fulfilling a medical need of a patient, or fungal nail services. They did not require any licensed authorization. They did not have to register. They did not need medically qualified people to carry out these procedures. Therefore, these were treated as standard rated and VAT was payable. The Skin Rich Limited lost their appeal. Personally, my view has always been, if there is a medical problem, general medical problem, and will you survive without treatment? If you will survive without treatment, your life will carry on, then that automatically means that whatever you're doing is more of a cosmetic nature and therefore not allowable for VAT, or not exempt from VAT. If there is a medical problem and you cannot survive without it, then there is a chance that you will get the VAT exemption. The next case is that of Hussain versus HMRC. In Hussain versus HMRC, Mr. Hussain was a shareholder and a director in a company. The company had a VAT liability and penalties, which they felt were, as HMRC felt, were because of the director's deliberate fraud. So they tried to transfer the liabilities from the company to Mr. Hussain as the director, which the HMRC are doing a lot more these days. So if the company goes into liquidation, HMRC try to transfer the liabilities onto the directors. Mr. Hussain then appealed against the HMRC's decision to transfer liabilities onto the director, and the matter went to the tribunal. In the tribunal, the judges asked a few questions, and they said HMRC had to prove there was fraudulent behaviour by Mr. Hussain. And for that, if they cannot prove fraudulent behaviour by Mr. Hussain, HMRC cannot transfer the liabilities onto the director, which was Mr. Hussain. And we're seeing a lot more. I've seen quite a few cases where HMRC allege fraud, or say there's deliberate behaviour involved in tax evasion, and therefore the penalties should be high. This is always, on this onus of proof is with HMRC. So they have to prove there was deliberate behaviour and fraud. And if they cannot prove the deliberate behaviour or fraud, then they cannot apply such excruciating penalties or transfer them onto the directors. The next case is that of Mr. Hunt versus HMRC. This was also announced in the last week or so. Very, very interesting case. Mr. Hunt had given a personal guarantee for a company who took a loan of roughly £17 million and unfortunately defaulted. So Mr. Hunt, as a personal guarantor, had to make good that loan. Mr. Hunt then tried to claim that loss in his tax return as a capital gain loss. HMRC denied that. The matter went to the tribunal, and it was proven that actually Mr. Hunt had taken the risk. The company had started to trade, but it failed. Operations failed, didn't do so well. So Mr. Hunt should be allowed the loss in his personal tax returns, which is I'm surprised HMRC took the view. But if there is a personal guarantee involved, they are usually allowed to claim loss relief. The last case is that of Graham versus HMRC. Very interesting case. Now this Mr. Graham had purchased some expensive cars, and he claimed VAT on those cars. Now normally you cannot claim VAT on a car even if there's just 1% of private use involved. So if you use the cars for private purposes, you can never claim VAT on them. Now on this one, Mr. Graham said, okay, I've never used these cars for private purposes. HMRC disagreed because this involved expensive cars, a Porsche and quite a few other expensive cars, and they were parked at his house as well. But during the course of the proceedings, he was able to prove or convince the judges that he just bought them to resell them, and he did not intend to use them for private purposes. And the judges agreed, and therefore the claim was allowed in full. There's all or nothing claim. There's no partial. Just because you use it for 20%, it doesn't mean that you can claim 20% of the VAT. It's all or nothing. But this was a very interesting decision, that and people who do buy cars for reselling need to make sure that there is no element of private use at all. Thank you very much for watching, and we shall see you next week. If you do like our videos, please like them on our channel. Thank you very much. Take care.